properly admitted cash recovered from defendant's person, notwithstanding defendant's objection that no meeting or mention of the cash had been made at the pretrial suppression hearing. Defendant had moved to suppress both drugs and cash, but proceeded to trial without calling either the hearing or trial court's attention to the fact that there was no hearing testimony about the recovery of the cash. Accordingly, defendant acquiesced in the hearing court's failure to address that issue. In any event, the trial court's decision to admit the cash into evidence could not have caused defendant any prejudice. Probable cause for the arrest had been established at the hearing, at which the court had denied suppression of the drugs, and defendant conceded in his arguments before the trial court that the only suppression issue was probably cause for the arrest. Similarly, on appeal, defendant has not established any basis under which he might have been entitled to suppression of the cash but not the drugs, even assuming that the circumstances may have warranted reopening the hearing for the purpose of taking testimony about the cash. Plaintiff's motion for summary judgment was properly granted upon proof of non-payment and in view of the subject agreement provisions that plaintiff made no representations or warranties of any kind with respect to the copier, and plaintiff was not the supplier, dealer, or manufacturer of the copier. That any warrants or warranties made by the supplier, dealer, or manufacturer were not part of the subject agreement, and that defendants would continue to make the payments due under the lease, even if the copier was for any reason unsatisfactory. These provisions are typical of a finance lease. It does not avail defendant that plaintiff and the copier's supplier are wholly owned subsidiaries of the manufacturer, and no basis exists for piercing these affiliates' corporate veil. Nor does it avail defendants to argue that the 10-day period measured from delivery that they had under the lease to give written notice of rejection and thereby avoid the hell or high water clause. Despite their many complaints about the copier, virtually from the time of its delivery, defendants continued to use it for some 8 months before giving clear notice that they wanted it removed from their premises. Clearly more time than was reasonably needed to decide whether they wanted to keep it despite its alleged defects. Clear and convincing, unanimously affirmed evidence supports family court's conclusion that despite the diligent efforts of petitioner agency, the relationship between respondent and the subject children failed to take any material steps for the resumption of parenting responsibilities. By not availing herself within the statutorily relevant time frame of the drug treatment and individual therapy regimens recommended by the agency, and by failing to maintain regular and continuous contact with the children in accordance with the agency's visitation schedule, respondent defaulted in meeting her obligation to plan for the children's future, thus warranting the finding of permanent neglect. See matter of Amanda R. 215, Appellate Division 2nd, 220. Leave denied, 86, New York 2nd, 705. In the case of Rosenberg versus Cohen, 28, New York Supplement 2nd, 553, as well as People versus Brown, 284, Appellate Division 2nd, 191, the event was anticipated. Other.
I think it was pretty good.